All right, it is 7 o'clock on the dot. We are gonna get started. Hello, Bestie. Hello, Miss Stacy. Wait, Bestie, was today the day? Did I have the date wrong? Was today the day or is it tomorrow? I think it's tomorrow. Yes, but let me know if you care to share or if you need help before you get ready. You passed! What? Oh my gosh! Yay! You passed! You passed! And you know what that means? You've earned your song. Oh my gosh. Let me make sure I've shared my sound. I love that for you. And
Good job, good job.
good
Good
job,
job,
good
good
job.
job.
G double O
G-double-O-D,
D J O
J-O-B,
B.
good
Good
job,
job,
good
good
job.
job. Hey, and
My money don't jiggle jiggle, it folds. I like to see you wiggle wiggle, for sure.
I love that for you. You worked your butt off to pass. I could not be more proud. I am not surprised. I am not surprised at all. But if you feel comfortable, would you mind coming off mute and telling people I mean, there's people live now, but then there's people who watch this later. What did you do to pass? What do you think helped you the most so that people can follow in your footsteps?
Well, first, when I found out I passed, I cried.
Uh, yeah, that
Boohooing
is
in the lobby.
acceptable. That is quite acceptable. Nobody is mad at that.
I guess the almost honest thing I can say is be give yourself grace. Realize that your journey is your journey. There's a lot of folks that are out there and they could pass on the first time. I actually took the test 5 times, and this is my sixth time. I just didn't give up on myself. Just don't give up on yourself. AI helped me so much. I took your suggestions, Candace, and I went to Claude and I created several AI exams, just like you did, and was testing from vocabulary to my state to national questions. Plus tutoring. It saved me. I was a few points away, and that was just enough to get me where I was. But the most important thing I would tell everybody is don't give up on yourself. It's
That is
follow
such
your
good
own journey.
advice.
Yeah, follow your
Good
own journey.
advice. I love
Mhm.
it. And the fact that you use AI, I like to call that vibe learning.
Yeah,
People say vibe coding, but there's vibe learning and
right,
using AI the right way.
right,
The
right.
right way. I'm so proud of you. So very proud of you. So
Thank you.
yay!
Thank
And we will
you.
have to have a phone call and discuss and celebrate everything all together. But so very proud of you. So yay!
Thank you.
Yay! I love that. Whoop
Thank
whoop.
you.
Sorry, I guess you were gonna tell us anyway, and I kind of stole your thunder. But
It's
I'm
okay.
okay
I've been
stealing your
dying to
thunder
call
for
you all
something like
day, but
that.
I was like, no, no, wait till 7. Wait till 7.
I'm glad you waited, and we shall chat later.
All
All right,
right.
well, then we're going to get into it. Oh, and Juana, who's on the YouTube, she's on the YouTube. Look, I'm sounding older every day. The YouTubes, I'm just going to claim it. She says, congratulations. So, oof. And Miss Stacy says done it 5 times also, but you'll never give up. Y'all, it's okay. 5 times? I've known people that have done this 11 times. And what I've discovered are the people, hey, Juana, the people who take their time and learn the information, they're going to do so much better, which is actually a segue into this new set of questions that I did today. We're starting from a question number one, but this time I tried to ask AI to give more scenario based questions, not just technical questions, but I even said scenarios they may run into in real life. Like, how do you apply this information to real life? So I don't know how AI did. We're going to find that out together, but don't give up, y'all. It is so worth it. And even better, it's worth it when you don't get sued so that you know how to take this information and use it and apply it for your actual real life because no lawsuits are funny and none of us look good in federal prison orange. So, oh, so amazing. All right, so let's try number one. Blow this up a little bit. Again, I haven't seen these either. Wanda deeds a parcel to a hospital so long as the property is used exclusively for medical care. 12 years later, the hospital converts the building into administrative offices with no patient care. Under the terms of this conveyance, what happens to title? Is it A, title reverts automatically to Wanda or her heirs without any need for legal action? Is it B, the property escheats to the state because the condition was violated? Is it C, Wanda must file a quiet title action within 1 year to recover the property? Or is it D, the hospital retains title, but Wanda may sue for damages caused by the changes in use? All right, this is a lot, and there's a lot of good. Hello, is it Jally? Jalea. It's what I see it. I saw Jally there, but it's Jalea. Hello, Miss Jalea. Hopefully I said that right. If not, correct me. So I like to go through and look at my question again, and what I saw as so long as this word right here, that tells me this is a fee simple conditional. Oh, not conditional. I'm going to say defeasible. And I happen to know that that term means a fee simple conditional, and this is going to be a determinable. This is a determinable estate. So long as, while, during, whenever you see that language, it is going to be, yeah, it's subject to something. Exactly. It's a type of fee simple defeasible estate, and it's a fee simple determinable, which means you promised, or when you received that property, you had to follow all of the rules and regulations that were put in as part of that ownership. Otherwise, it automatically reverts back to the original owner. Or if they had done a conditional, the owner could go to court and get ownership back. But let's see, knowing that's a fee simple determinable, let's see which answer meets the, which answer is correct. So is it A, title reverts automatically to Wanda or her heirs without any need for legal action? Yes, I love that answer because it says it automatically reverts. Love that, but let's go through and make sure the other ones are wrong. Is it B, the property escheats to the state because the condition was violated? No. We know when something escheats to the state, it's because somebody died with no heirs and no will. So it's not B. Wanda must file a quiet title action within 1 year to recover the property. No, that would be if it was conditional. Or C, the hospital remains title, but she may sue for damages caused. I mean, you can sue for anything, but that's not our answer. Our actual answer is A. I love it. There we go. Nice job, ladies, getting that right. All right, number 2. Two brothers, Carl and Pete, own a lake house as joint tenants with the right of survivorship. That's important. Carl, without telling Pete, sells his interest to a third party, Diane. What is Diane's ownership status with Pete after the sale? Is it A, Diane and Pete own the property as tenants in common? B, Diane and Pete continue to hold the property as joint tenants with the right of survivorship? C, Diane becomes a joint tenant, but Pete's survivorship rights are extinguished? Or D, the sale is void because joint tenants cannot transfer their interest without the other's owner's consent? All right, Ms. Val, you are telling me that it's A. Ms. Stacy, you're telling me that it's A. Okay, so we like A. I like A, but let's make sure the other ones are wrong. Well, we know it can't be joint tenants with the right of survivorship because in our scenario of possession, interest, title, and time, Diane did not get the ownership on the same document at the same time, even though possession and interest are equal. So that can't be the right answer. Diane can't become a joint tenant because Pitt, that can't be the right answer. And the sale is not void. You can't transfer your interest without the owner's consent. That would be tenants by the entirety. You cannot transfer without everybody's apples and apricots. I like to eat apples and apricots, of course. So it's not D either. Our answer is A. And again, I know I'm always sounding like this is on repeat, y'all, but if you're somebody who still needs to pass, making sure you understand why the wrong answers are wrong, because this is a great review of tenants by the entirety. This right here is a testable fact. about D is a testable fact about tenants by the entirety. So yeah, we're getting multiple levels of learning in here. Hello, Miss Crystal. You said you took the exam, you passed the national, but you barely passed the state. That's okay. We still celebrate our wins over here because now all you have to do is study for your state section. So you get a
Good job, good job.
good job, good job. G-double-O-D-J-O-B, good job, good job. And you get a
My money don't jiggle jiggle, it folds. I like to see you wiggle wiggle, for sure.
yes, we had another person pass one of their exams. Yes, in North Carolina, you got 2 exams to pass, but Crystal, you are halfway there. Now all you have to do is pass that other half and you will be good. And you can focus all of what you need to know on that. So that is, don't worry, it's going to go so much faster. It's fewer questions and you know exactly what you have to study. So that's awesome. I love that. All right, number 3. Oh my gosh, this is such a good day. People passing. Farmer Dole sells the rear half of his land to a neighbor, landlocking the parcel with no access to the public road except across Dole's remaining land. The buyer never negotiated a right-of-way in the deed. What is the buyer's best legal claim to access the road? Is it A, a prescriptive easement, since the buyer will eventually gain rights through continued use? B, an easement in gross, allowing personal use of Dole's driveway? C, a license which Dole can revoke at any time? Or D, an easement by necessity, implied by law because the parcel was landlocked by division of a single tract? Okay. So we know when it comes to easements, there's 2 things you need to know. Now we know an easement is a type of encumbrance. It's one type of an encumbrance. And easements have types, and you can talk about how they're created. Right? There's types of easements, whether it's a personal easement in gross, a commercial easement in gross, or it could be an appurtenant easement. And then how easements are created, you could do it because somebody just gives it to you. It could be through prescription. It could be, I mean, there's all sorts of ways that easements can be created. We're kind of dealing here more, well, I think this question kind of combines the 2, and you want to make sure you understand both. So, and Miss Crystal, Juana says congratulations, by the way. So, a prescriptive easement, since the buyer will eventually gain rights through continued use. Well, that's probably not the best way. It's asking for the best legal claim to access the road. Farmer Dole could have granted an easement when he split off the property. And that would be a lot easier than having to wait to meet some kind of legal statutory time limit on how long you have to use this. So I don't think that's the best answer. I think prescriptive easement is not your best choice. And she says, thank you, Miss Juana. An easement in gross, allowing personal use of Dole's driveway. Well, an easement in gross, we know, could be a commercial easement in gross having to do with utilities, but it also could be a personal easement in gross, which means when the person dies, when the buyer dies, the easement would be over. And that's going to be problematic for whoever gets the easement or gets the property after the buyer dies. So I don't think that's our best answer. C, a license which Dole can revoke at any time. No, absolutely not. What if you and Farmer Dole have a problem and he gets mad at you so he can revoke it? Absolutely not. Let's see if D is in fact our best answer. An easement by necessity, implied by law because the parcel was landlocked by the division of a single tract. I like that. Yeah, I like that. If Farmer Dole didn't give you one to begin with, you could go to court and ask for an easement by necessity. Look, this is a necessary because I need to be able to reach my land. That would be helpful.
Candace.
So, yes, go for it.
So An easement by prescription, I know, is basically kind of like taking over. However, that person lets you do it for like, a very long period of time. It doesn't say anything, right?
Mhm.
So is it because the farmer dole sells the rear half of the land to the neighbor and landlocking the parcel with no access?
Yeah, I mean, if you have these two pieces of land
Right,
and here's the road,
right,
if this is the property, that Farmer Dole sold, he gave this buyer the new property. And
right.
without you have to have access.
So it's
What
kind of
farmer
like saying he knew he should give him access, but he's just being a jerk in a sense.
Yeah, he
Okay,
knew,
okay,
and partially the law steps in, and this comes to your bundle of rights.
right,
Our bundle of rights, he have the right to possess, the right to use, and you can't do that if you can't get to it.
correct. Okay, yeah,
So
because it said it was
necessity.
never. Yeah, it says it was never negotiated right away in the deed, which is kind of crazy because he knew that that's where the prescription would not apply because it's like, well, how the heck am I going to get to my house? You know
Well,
what I mean?
let's say this happened 70 years ago,
Okay,
and nobody thought about the easement.
right,
Then yes, you could say a prescriptive easement because we've been using this for 70 years. And
right,
that could be why, you could say, hey, it doesn't matter if you want to. Even if it wasn't necessary, even if over the 70 years a
mhm,
new road came here, but everybody was always using this right here because it was closer to the highway.
right,
After 70 years, even though it's no longer necessary, you could still claim an easement by prescription. Hey,
right,
I've been doing it for 70 years.
right,
But
right,
because it's new, you want to
right,
do it. Even if it was brand new, you could go to a judge and be like, this fool did not give me an easement.
right.
And again, I think, not to beat a dead horse, but I'm going to do it anyway. Who cares about the horse? This is why I always want you all to learn and not memorize. Because if you have if your client is Farmer John or you're
Hmm.
the buyer's agent, you want to be like, somebody needs to give an easement. The average person doesn't know anything about easements, and you all with this knowledge do. So the
So
goal.
as an agent, right? Let's just say we're agents to that seller, right?
Mhm.
And we have a buyer. We can always say to our seller, like, so what kind of easement are you going to provide to the buyer?
You know what? Yes, I'm going to tweak it a little bit. You'd be like, hey, seller, you probably want to talk to an attorney
I
or a
gotcha.
title person
Right, right.
about making sure you give the correct easements. Because
Okay.
our job, I'm doing a recording right now, and I'm literally just did a recording earlier today. I said, your job is not to illegally practice law. Your
Correct.
job is to know when to tell somebody to call an attorney.
Yeah, stay in your lane in a sense, like we talked
Stay
about
in your
before.
lane, but know what the lanes are, because if
Yeah,
nobody tells them to call an attorney, it's going to blow up in their face later.
exactly. Okay.
That's
All right.
why we learn all this random crap. So
Yeah, yeah.
there you go.
Thanks. I
Yay.
appreciate
Great
it.
question. Yay. And I like these so far, like these scenarios, because this is what I want you all to do in real life. Call an attorney. Okay. Number 4. A contractor completes a kitchen remodel for a homeowner but is never paid. Before recording a mechanics lien, the contractor learns the homeowner refinanced the property with a new mortgage 2 weeks after the work began. If the contractor files a valid mechanics lien, from what point will most states measure its priority against the new mortgage? So I'm going to draw out a timeline here. The house exists, and then there was a kitchen remodel. And it says, before recording a mechanics lien, the contractor learns the homeowner refinanced the property with a new mortgage 2 weeks after the work began. So then there's a new mortgage. So at what point will most states measure its priority against the new mortgage? So what would be paid first? Assuming there was no other previous, liens that needed to be paid, forget about tax liens. Who would be paid first, the remodel or the new mortgage? So we'll look at our answer choices. Would it be, if we're looking at priority against the new mortgage, from what point will most states measure its priority? From the date of the final invoice that was issued to the homeowner, from the date of the mechanics lien is recorded in public records, from the date the homeowner signed the remodeling contract, or from the date the contractor's work actually began on the property, not the date the lien was recorded. All right. So I see I see my favorite in the chat over here, and Zoom is Valerie. You gave me these nuts. Yes, our answer is D. Right? The answer is D. Even if the invoice comes here, most states will say, look, we're going to cover this lien covers the first day you started work. So even though this mortgage lien was recorded first, the date as far as what gets applied so we can pay things off is going to be from this date, making our answer D. Nice job. Nice job, ladies. And number 5. An investor purchases a foreclosed property directly from a bank, which conveys the property by special warranty deed. Okay, special warranty deed. 2 years later, a title defect surfaces that originated with an owner from 15 years before the bank ever held title. Can the investor pursue the bank under the deed's warranties? That's our question. Can the investor pursue the bank under the deed's warranties? So it came from a bank to the new owner by special deed. So let's see, what do we think here? We know there's types of deeds. Sure, can I go over special warranty deeds? Yeah, well, we know when there's general deeds. You know, there's a deed, just deeds, but then you've got general warranty deeds. Then you've got special warranty deeds. And then you kind of have quit claim deeds. Those are your 3 major ones. We know general warranty deed covers forever. If I were to give you, Valerie, a general warranty deed, I'm saying, look, I'm promising that I'm giving you good title, but I'm also promising that if anybody comes and says, I didn't give you good title, I'll clear it up. And on top of that, even if somebody comes along that says, before I owned it, they had a claim to the title, I'll cover that too. I'll cover anybody, no matter what time it happened. I will make sure that you get good title. Versus your special warranty deed is me saying, look, I know I didn't mess up the title, but I got the title from Crystal. And we all know Crystal's a little shady. So if Crystal messed it up or somebody previous to me, I can't help you. But if somebody comes along, if Stacy comes and says, well, while Candace had the property, you know, I did it, then yeah, I'll clear that up. And if it was quit claim deed, you know, I'm just saying it's yours. I'm not even saying I own it. I'm saying hot potato is your problem now. Do not call me. My name is Bennett and I ain't in it. So hopefully that helps as a reminder. Let's look. Can the investor pursue the bank under the deed's warranties? Yes, because a special warranty deed guarantees clear title against all defects, regardless of when they arose. Nope, because that would be a general warranty deed, or just called a warranty deed sometimes. B, no, because banks are exempt from all deeds warranties. They wish. I'm surprised they didn't get that put into law. C, yes, but only if the defect was recorded in the county where the bank is headquartered. I mean, is that true? I don't think that the recording has anything to do with it. If you wanted all defects, you needed to get a special warranty deed. Our answer is not C. Instead, we are going to go with D. And it's going to be no, because a special warranty deed only warrants defects arising during the bank's own period of ownership. That is our correct answer. Love it. All right. 6. No, just out of curiosity, 4, 2 people who just passed. So that would be Valerie and Crystal. Did you find on your exams, this is don't tell me the exact questions, but did you find your questions on your exam were more scenario based like this? Or were they more just straightforward or like other questions that we've done before?
For the state of Georgia, it was a combination.
It was a combination. All right. And what about you, Miss Crystal?
Same.
Combination. All right. So once we finish this set of questions, what you're saying is the next set should be a mix of this type of scenario plus kind of the more straightforward questions.
And you
Yeah.
definitely needed to know the definitions.
Oh,
Yeah. Yeah. If you don't know your vocabulary, you're going to be struggling.
Okay. I just like to, we're trying to, maybe one day I'll get to the point where the questions I write will be, and by I mean AI, right? That would be as similar to the real estate exams as I could possibly be. But
yeah,
thanks,
when I
lady.
created my AI, I did a combination of scenarios, straightforward answers, vocabulary, and math.
Ah, okay. Let me write that down so everybody sees it. You did scenarios,
Straight vocabulary,
straight vocab,
math,
and
then just straight answers like how many acres or just
yeah,
real
just
easy ones.
definitions.
Yeah, just definitions, but more of a multiple, and all of it was multiple choice.
All right. So if that helps anybody, that's how she did her AI questions. And you can go back and look at previous videos I've done on how to use AI to do this. Y'all, AI is free. You may not get the same level of quality, but it's still going to be free enough that you don't have to go out and spend $40, $50 on a book. Or if you are going to spend even $20 on a book, that's 1 month of AI. Use some AI to get you some good questions. All right, number 6. Thank you, Ms. Val. Thank you, Ms. Crystal. An elderly father signs a deed conveying a farm to his daughter and places it in his desk drawer, telling no one. He dies 6 months later, and the deed is discovered among his papers. Did title pass to his daughter? Yes. A, yes, because signing a deed is sufficient by itself to transfer title. B, no, because the deed was never delivered to the daughter during the father's lifetime. C, yes, because the daughter's relationship as an heir satisfies the delivery requirement. Or D, no, because the deed also needed to be recorded before the father's death to pass title. So let's go through it. Yes, because signing a deed is sufficient by itself to transfer title. No, that's not the answer. We're talking about the essential elements of a deed, what you need in order for a deed to be valid. And that would be, I get paid with every deal. It needs to be in writing. It needs to have a grantor, must be competent, and the grantor must sign. It has to have a legal description, a property description. I think my handwriting's getting worse as I get older. It needs to have words of conveyance. It needs to be executed. And of course, signed by that grantor. So it's the grantor who has to sign. And then the fact that it has to be signed in and of itself is a reason. And it has to be delivered and accepted. It must have these things, otherwise you don't have a valid deed. And you have to have more than just signed. It needs to be delivered and accepted. So it's not yes. No, because the deed was never delivered to the daughter during the family's lifetime. I like that, but let's eliminate other ones. Yes, because the daughter's relationship as an heir satisfies the delivery requirement. No, no, no. Or no, because the deed also needed to be recorded before the father's death. And this one would try to trick you, but no place on here do we have an R. Deeds don't have to be recorded in order to be valid. You recorded them for the protection, not to require them to be valid. So our answer is not D. Our answer is
C is for cookie. That's good enough for me.
All right. So I'm sick of green. Let's go to a new color, not red. Let's go to pink-ish. Close enough. 7. A homeowner has openly maintained a fenced strip of land. maintained and fenced, that's what it says, a strip of land belonging to her neighbor for 22 years, believing it to be part of her own lot. The statutory period for adverse possession in the state is 20 years. The neighbor never objected. What is the legal effect? Is it A, the homeowner may acquire legal title to the strip through adverse possession? B, the homeowner must pay the neighbor for the value of the land before title can transfer? C, the neighbor retains title permanently because adverse possession cannot apply to residential property? Or D, the homeowner has no legal claim because she mistakenly believed the land was hers rather than intentionally trespassing. All right, what do we think for number 7? What do we think for number 7? Well, let me help y'all out. It's not C. It's not C. Adverse possession does apply to residential properties. Now, note, doing you all a favor for all my attorneys and title people out there, escrow agents. Just because we learn about adverse possession does not mean it happens all the time in real estate. It's just kind of like that four-leaf clover. It sometimes appears and sometimes it doesn't. Just don't get overly excited. But it's just not D, because it doesn't matter that you mistakenly believe the land was yours. That has nothing to do with it. I believe I should win the lottery. Apparently, that has nothing to do with me being rich. Rude. So is it A or is it B? The homeowner may acquire title through adverse possession, or the homeowner must pay the neighbor for the value of land before title can transfer. By the way, it is not B. Our actual answer is A. A for apples and apricots. I don't know why that saying pork chops and applesauce just went through my head. The A is for the applesauce. Nice. And just remember, adverse possession, just a review, use has to be open, continuous, exclusive, actual, and notorious. Or the A could stand for adverse, meaning you never had permission. Okay, number 8. A brokerage represents both the buyer and the seller in the same transaction with informed consent. That's dual agency. From both parties. During negotiations, the buyer privately tells the agent she would pay $10,000 more if necessary. What is the agent's obligation regarding this information? Is it A, the agent must withdraw from representing either party once confidential financial information is shared? Is it B, the agent must disclose the buyer's maximum price to the seller to fulfill the duty of full disclosure? Is it C, the agent may disclose the information only if the seller asks directly? Or is it D, the agent must keep the buyer's maximum price confidential and may not disclose it to the seller? All right, so Miss Crystal, you said D. Miss Valerie, you said B. And Miss Stacy, you said D. All right, so let's look at A and C. The agent must withdraw from representing either party, not unless you're in a state that doesn't practice dual agency or something like that, but this is a national question, so that's not our answer. C, may disclose the information only if the seller asks directly. Y'all knew that wasn't the option. Let's look at the difference between B and D. The agent must keep the buyer's maximum price confidential, or the agent must disclose the buyer's maximum price to the seller due to the duty of full disclosure. This is dual agency, and you can't hurt or help one client over the other, which means it is most definitely not going to be B. Our answer is D. You can't give all of your full fiduciary duties in dual agency. It's not possible, because to be truthful to one might hurt the other, and that is a problem, which is why some states make it, some states make this illegal. I mean, that's just the way this works, right?
So, Candace, I have
Yeah.
a question. I'm in a state where that's illegal, right? They don't do dual agency in Georgia.
Okay.
So is it because you're kind of stuck between a rock and a hard place?
Yes.
It's like you can't do one and you can't do another. It's like holding
Yes.
it's like holding a secret, though you know,
Yeah,
and you really
it's
can't tell that secret. You know what I mean?
it's the same reason why if you were being represented in court as an attorney, like you had a defense attorney,
Right.
would you want your defense attorney to also be the prosecutor?
No, absolutely not. No.
Which is why a lot of attorneys just so guys, and that's a short story. So North Carolina recently, our real estate commission recently had a vote whether the state should get rid of dual agency. Now they had to take it back to the drawing board, but one of the things I found interesting, there were all of these agents that were like, yes, I mean, this is terrible. No, do not get rid of dual agency. Yes, dual agency is fine. Dual agency is good. And then one of the commission members said, and I didn't prove this, but one of the commission members said, yeah, we got some letters from an attorney. And every single attorney was like, dual agency is bad. Because in the attorney world, how do you represent two clients fairly? That's why we have judges. So I'm not saying dual agency is terrible and nobody should do it, although personally, I think dual agency is terrible and nobody should do it. But hey, do you? But just make sure whatever you do, you're trying to be, just don't do anything that can get you sued
That's
or
hard.
be in a state where it's illegal.
That's hard. That's hard.
I mean, people can say that about their kids, but as a favorite child, I can know, my dad will tell you he loves all of his children equally, but everybody in the family knows that is a lie.
You're the favorite.
Maury has told us that is a lie. And my siblings are like, this is ridiculous. And my mother is like, you are rotten. Well, can't help being the favorite. Somebody's going to end up winning.
Right.
Even if you don't mean to. Or an example I give sometimes is you're a dual agent.
Right.
One hand, you got a buyer who are teachers having their first kid. I don't care what state you are in America. Those teachers are not paid enough. The other is a widow who lost his wife and his life savings trying to save his wife and make her comfortable towards the end of her life. So he needs every single penny towards retirement. And then they ask you for help in trying to find a purchase price. Is it fair to split it down the middle? Do you give a little bit more to the widow because he's not going to make as much money for the rest of his life? Or the two teachers giving their life to educating children with a kid on the way? Somebody's got to help them draw a line. How do you do that in dual agency if they're looking for advice? So there you go. Yeah, I don't know what I would do. That's hard. You'd have to hopefully implicit bias wouldn't kick in because that's a problem. All right, number 9. An agent representing a seller under a single agency agreement also secretly helps the buyer negotiate a lower price and shares the seller's bottom line figure with the buyer without the seller's knowledge. What has the agent committed? They've committed to have me slice their tires. I mean, that's not an answer choice. Is it A, a breach of fiduciary duty through an undisclosed dual agency and disclosure of confidential information, which Miss Crystal is saying is the right answer. And so is Miss Valerie. Oh, and so is Miss Stacy. B, acceptable conduct as long as they want to have their tires slashed. No, that's not the right answer. B, a permissible facilitation of a transaction since both parties benefited from the lower price. No, both parties didn't benefit from that lower price. And D, a minor administrative error correctable by informing the seller after closing. And if you want to get sued. So yes, our answer is A. Okay. Number 10. A property management company signs a contract with an owner authorizing it to lease units, collect rent, hire maintenance vendors, and handle day-to-day operations of an apartment complex on an ongoing basis. What type of agency relationship exists? Now, as much as I tell you all not to just memorize, hopefully there's some stuff that you just know off the top of your head. So when I say what are the types of overall agency, you go, there's a universal agent, there's a general agent, there's a special agent. And if what you do is memorize property management is general agency, I want you to understand why, but if that's all you know, then that would be the knowledge you know to go, let me find which answer says general agency. Hey, look, it's 10. Now, we're still going to go through and make sure we understand why the other ones are not right. But, there is something to that whole memorization of just some basic facts. Well, we know it's not universal agency because it's only doing the day-to-day operations of an apartment complex, not that clients, everything in their life. It's not that. And it's not special agency because they have the authorization to do some things and make some independent decisions without the owner being present every time. And it's not designated agency because that's a type of real estate sales agency. That's a type of sales agency, not just agency in general. Sorry, was thirsty. Let's move on to 11. Oh, question. I know I'm just full of questions to you all. I have a set of questions that I'm going to do, a YouTube video on, not just a live, but a YouTube video where I go over all of these questions I haven't done here on the lives. When you all are watching my videos, do you like it better when it's just me and I'm talking? Or should I find a couple of you all, maybe 5 or 6 of you all, to be in a closed Zoom session? I record it, and then you all watching on Zoom later can hear the questions that people asked. Does anybody have any feelings on that? If so, let me know. I'll probably do it sometime next week, but I'm just wondering what you prefer. And I move on to 11. Close Zoom for more interaction. Okay, we got a close Zoom for more interaction. All right. A closed Zoom for more interaction. That's 2. Do I have a third? So Miss Valerie, you're done now. I mean, if you want to do it too, you can. And Miss Stacy, I will definitely let you know when it is. Or if anybody via YouTube wants to be involved, let me know, email me. But it sounds like I need to schedule something for a closed Zoom. Crystal says it doesn't matter. Way to not break an answer there, Miss Crystal. I'm just, it's like, wait a minute, break. I will probably do one for North Carolina specific stuff, Miss Crystal. So if I do, and you haven't passed yet, so it'll probably be a couple of weeks. Mm-hmm. Oh, I'm not getting rid of you. Good. I had no intention. All right, number 11. I will let people know when it is. And then those people who come to these lives or watch them recording, I'll put up something. Maybe I'll do, an ad or something. I'll just need like 5 or 6 people for the recording of those questions. And then we'll just put it on the YouTubes. And if you're somebody watching later and you're interested, don't forget to email me, Candace Ellis. That's not how you spell my name. Ellis@gmail. Oh, and Jalia, did I say that right? Jalia. Well, however you say your name. If you're interested, email me. Also, let me know how to say your name correctly because I hate when I mess up people's names. 11. A buyer's purchase agreement includes a financing contingency requiring loan approval within 30 days, with the contingency automatically expiring if not extended in writing. On day 32, having neither obtained approval nor requested an extension, the buyer informs the seller she still wants to proceed and expects the seller to wait. What is the seller's position? So there's a financing contingency and there has to be loan approval with 30 days and the contingency automatically expired. So I haven't looked at these answer choices, but what I know is that a contingency is usually an out. But you, especially the buyer's purchase agreement usually says, hey, if I can't get a loan approval by X date, then I don't have to buy your house. But they waited for 2 days after. So it sounds to me like, the buyer still wants to buy and the seller could be like, okay. But, I mean, I'm not seeing, I don't have the details of that contingency there. But I don't know. Is it a contingency for the seller? Let's see what our answer choices is. I don't know. The seller must still wait because financing contingencies are automatically extended under a contract law. No, they're not automatically extended. The seller may treat the financing contingency as expired and is no longer obligated to wait for the buyer's loan approval. Maybe, depending on how that contingency is written, that's a maybe. Right, I'm going to leave that alone for right now. The buyer can force the seller to perform because she expressed continued intent to buy, not by the correct date. Nope, she missed that date. Or the contract is automatically void. Well, no, that's not true either. It's a contingency, which means the whole contract it's not void. Usually a contingency gives somebody the right to back out or to not do something or something else kicks in. So it's not D. By process of elimination, I'm going to say it's B. Because in my mind, a financing contingency usually says, dear seller, hey, if I can't get a loan, I don't have to buy your house. But also, sometimes you have contingencies where it'll say, dear seller, I have a house to sell. And if I can't sell the house and show you proof of that, you don't have to sell it to me by this date. If I don't show you by this date, you don't have to sell it to me. So sometimes it could be the seller not having to sell the house if you don't meet the contingency. So I got to go with B because it's my best answer choice. Is it the choice I would have first answered if you said, give me, if this was an essay question? No. But I feel good about A, C, and D being wrong. So I'm going to check and see what, AI says. Is 11 the right answer? Survey says, hey, the answer is B. The answer is B. Hey, the answer is B. All right. There you go. That's my thought process. A little bit overkill, but it got me there. 12. A purchase contract states that if the buyer defaults, the seller's sole remedy is to retain the buyer's $15,000 earnest money deposit as liquidated damages. The buyer defaults and the seller's actual damages from the failed sale total $40,000. Can the seller recover the additional $25,000 from the buyer? Okay. Well, the contract stated that the seller's sole remedy is to retain the earnest money deposit. So can the seller recover an additional $25,000 from the buyer? No, it was their sole remedy. You should have asked for more earnest money. So I already know the answer is no. It's not A, it's not C. No, because earnest money deposits can never exceed 10% of the purchase price. That's not true. It's got to be D. No, because a valid liquidated damages clause limits the seller's remedy to the amount specified, regardless of the actual losses. Boom. D it is.
Question.
Hello, sir. Jalea. Okay, I got it. Jalea. I got it right. Mm-hmm.
Can I ask you a question, Candace?
Yes. What's your question?
I'm sorry to bother you. So
No,
let's just say,
we like questions.
okay, so are you saying, I'm just being facetious, if the seller requested, I don't know, $50,000, then they would be in the rights to ask for the $15,000 earnest money plus the additional $25,000 due to that $40,000 failed sale. Is that what you're saying?
No, I'm saying when that seller signed something that said the earnest money was their sole remedy, the seller is signing a piece of paper that says the most I can ever get from you is $15,000.
Gotcha.
If that seller thought that they were going to have more losses, they should have tried to get a higher earnest money amount.
I gotcha. Okay.
So that's why the sole remedy thing, and it's liquidated damages. In some states, like North Carolina, our contract says the earnest money is, serving as liquidated damages, which by definition is an agreed upon amount that if somebody breaches, here's what you get. Whether your actual losses are more or less, this is the number they're going to take.
Okay.
Some states it won't say they're liquidated damages, but they serve in the same manner. So
Yeah, in
Yeah.
Georgia, they state liquidated damages. That's why I was asking. So,
Yep.
Okay.
Yep.
Okay.
Exactly. And this is, again, one of those scenarios why we're doing this, because this is a real life type of thing. Your seller's going to be real pissed if you were the seller's agent and they're like, I'm only getting to get that $15,000. What about my other 25?
Right.
Well, seller, you probably should have understood what you signed before you signed it.
Right. Right.
Now, I would not suggest anybody say it to their seller that way if you want to continue to do business with them. But if you are old like me and have no patience for said things, you'd be like, well, dummy, you shouldn't have signed it. That's probably why I teach. All right, 13. A tenant with a documented anxiety disorder asked her landlord for permission to keep an emotional support animal, a raccoon, with a building with a strict no pets policy. The landlord denies the request solely because of the no pets policy. Under the Fair Housing Act, remember, this is federal. We're not acting what your state does. We're talking about what does the federal law say? Is this denial lawful? So we already know Fair Housing Act, Fred's Corn, familial status, race, disability or differently abled, sex, color, religion, national origin, Fred's Corn. And when we talk about differently abled or disability, that is mental and physical disabilities. And those support animals can be considered a part of that disability. So they're not considered pets. Those support animals are not considered pets. You cannot be charged a pet deposit for those. So is this denial lawful? No, it's not. Yes. Emotional support animals are only protected under Americans with Disabilities Act. It's actually the opposite of that. It is actually the opposite. The ADA only protects not emotional support, but assistance dogs, like seeing eye dogs. That's it. The protections for emotional support comes from what am I trying to say? Fair housing laws. Boom. And it's not D, yes, because uniformly applied no pets policy cannot be considered discriminatory. That's a problem. So is it B, no, but only if the tenant pays an additional non-refundable pet deposit? Or C, no, because the landlord must make reasonable accommodations for tenants with disabilities, including waiving no pets policy for an assistance animal. You know what I'm liking? You know what I like.
I like carrots, and you should too. It goes crunch, 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 and it's good for you. We like carrots, and you should too. It goes crunch, crunch, crunch.
One day that song's going to come on in somebody's kid's playground grocery store, and I'm going to be jamming. But yes, our answer is C, for carrots. All right, 14. A real estate agent working with an Asian American family only shows them listings in neighborhoods with large Asian American populations, despite the family's request to see homes in several other areas of the city. What violation has likely occurred? First of all, I don't care what their request was. You can't do this as an agent. You cannot make housing decisions based on anybody's race ever, whether they ask you to or not. This is a big fat not today, Satan. Not today. So is it what violation has likely occurred? No violation? That's not right. Because since the agent believed the family would be more comfortable. You know what they say about intentions in the road to hell? I mean, that's bad. Blockbusting because the agent is trying to influence the racial makeup of the neighborhood. No, blockbusting is where we get sellers to move because you're trying to, try to say a race or something's coming in or protected class. Redlining is not the answer. That has to do with lending. Or steering, which has to do with buyers, a violation of the Fair Housing Act based on race or national origin. Absolutely D is our answer. Okay, now, Crystal, that looks like a tire. I know I'm a little slow. I swear that's a tire. Tire starts with T. Wheel. Help me out, Crystal.
The closest wheel I could find.
Oh, the wheel for driving and the steering. Oh, a steering wheel. Okay, I got you. I was a little slow on the uptake. A little slow on the uptake there, girl. I had to get there. Had to get there. But I like it now. I like it. I will accept T for tire for D because steering. I got you. I'll accept that. All right, 15. A veteran wants to purchase a home with no down payment and without paying monthly private mortgage insurance, despite financing more than 80% of the property's value. Which loan program is designed to offer these specific benefits? So, which one has basically going to say no down payment in no PMI, and you're going to borrow more than 80% of the value? Is it going to be a USDA guaranteed loan, an FHA loan, a VA guaranteed loan, or a conventional loan with lender paid mortgage insurance? Well, it's not D, right? We know it's not D. And we know it's not FHA because we know the bank makes the loan in FHA loans, but then there is, mortgage insurance is just a little cheaper. So now we're down to a VA guaranteed loan. I mean, I tend to go with the no down payment means it's probably going to be a VA loan. Now, whether or not they can apply for it, are you a veteran? That's got to be it. But a VA loan will get you no down payment, no PMI, and you could do up to 100% of the value. A USDA loan, you might have to put a little bit down and you may have to pay some mortgage insurance. So, yeah, C, a VA guaranteed loan. There we go. All right. How many years does a VA cover? I'm pretty sure they're usually 30, but you may be able to get that extended out and have a longer amortization term. That's the word I'm looking for. Term. All right. Ooh, 16. We haven't done math yet today. I guess we're here. A broker's total commission on the sale of a $340,000 home is 5.5%. The listing broker and selling broker split the commission equally, and the salesperson who brought the buyer receives 55% of the selling broker's share. How much does that salesperson earn? Well, we're going to take this $340,000, multiply it by 5.5%, and that's going to give me a total commission. Where's my handy dandy calculator? Get off, cat. Oh, my cat was warming the calculator. It's so nice of them. 340,000 times 5.5%. I got a total of $18,700 for a total commission that got split equally between the listing broker and the selling broker. So I'm going to do 18,700 divided and multiplied by 50% or divided by 2. That's going to give me 9,350 to each side. And then that salesperson gets 55% of that. We're asking how much does the salesperson earn? So I'm going to take the $9,350 and I'm going to multiply it by 55%. What answer did you get? Oh, Stacy calculated it that fast. Oh, okay, Stacy, I see you. Are you calling me slow here, Stacy? You've been practicing. I love it. Stacy said, I'm not fast. I've just been practicing the way you told me to. Now, I got $5,142. $5,142.50. Final answer, which matches D. Hey, I love it. Now, we see that was an answer choice. I don't know where they got these from, but it's not our answer. 17. Ooh, we have a couple of math problems coming up. Well, let's hit it. Agent Rosa needs to net $6,000 after her broker takes. Valerie, I see you. We got it right. We got it right. Hey, we got it right. And Miss Crystal, you were still figuring it out. So let me rewind. Was this what you were going to do, Miss Crystal? Good. Yes, that's what you were going to do. I love that. Making sure. All right, number 17. Agent Rosa needs to net $6,000 after her broker takes 30% share of her commission on a listing side sale. The total commission of the sale is 6% of the sales price. Rosa's brokerage receives half of that total commission. What sales price is required for Rosa to net exactly $6,000? So what we're trying to do here, and I'm going to choose a different color. We're trying to say, what if we wanted this answer to be $6,000? And what if this right here was 50%? And what if I had to see 6%? Wait, I take that back. Let me see. So her broker takes 30%. So this would be 70%. Excuse me. She gets 70% of the commission, and it's a 6% sales price. So I'm going to do the math someplace else, but in just showing you, in this question, we started here with 340. And this question 16. In question 17, we're starting here. So I'm going to do this math backwards. Right? So if she took $6,000 home, and there was a split where whatever the commission was to the firm, she got 70%. Whatever her firm got, she got to take 30% of, well, her broker took 30% and she got to net 70. So we need to find out what this answer is. So I'm going to take that 6,000 and I'm going to divide it by 70% to give me an answer of what the firm was. Where's my calculator? $6,000 divided by 70%. I got $8,571.42. So her firm received the $8571.42, but then she got 70% of that, which is how she ended up with 6,000. That's what the firm got, but that was the brokerage got half of whatever the total commission was. So this was half of the total commission. I can take the $8,571.42 and multiply it by 2 to see what the total commission was in general, times 2, which gave me $17,142.85. And I know that $17,142.85 is 6% of whatever the sales price was. Now here, this step and this step, I kind of jumped ahead. And if anybody needs me to explain why, I don't mind. All right. So I'm going to take that 18,478 and divide by 6%. And I got 285, 714, and 28 cents. Now, obviously, we usually don't do sales prices like that, but hey, those are the numbers they gave me. So, oh no, am I right? Did anybody else get that answer? All right. Oh, okay.
I did.
Okay, and Miss Valerie, you did. Let's see if we are right. Miss Jalea, you got that answer faster than I did. Number 17, D, is our answer for do a little dance, do a little dance, do a little dance, do a little dance. Hey, hey, hey. Yes, yes. D is our answer. Nice job, ladies and gentlemen. Ladies and gentlemen. It's the beginning of a Sierra song. Ooh. I clearly didn't take my medicine today. I'm all over the place. But yes, ladies and gentlemen is the beginning of a Sierra song. Thank you very much. 18. Yes, that was a tough one. It was a tough one. And I do want to say, remember, guys, you could use the tree method. I did not use the tree method to do that. I kind of treed it in my head, but there is nothing wrong with using the tree method to do this at all. 18. And remember, I know it's 8:04, but I said if I got to go live on TikToks, I would do longer Sundays. So this is me doing longer Sundays. I don't mind. I'm having fun. Can you email me for the tree method? Yeah. I'm pretty sure that I have some videos on it, but yes, the tree method, actually, I think I can show you. I can show you the tree method very quickly. I hate when they change the order of everything. No. I think this is it. Yeah, math and handouts, maybe? Tree method. It looks like this. It's just a flow chart. So you start with a list price or a sales price. And whatever that is, you would multiply it by your rate of commission that gives you a total commission. And then there's a split between the seller's firm and the buyer's firm. So you would insert whatever that split is. And then whatever the firm gets, there'd be another split here between what the agent gets and the firm gets. Sometimes there may be a franchise fee. And yeah, you can email me. I can send it to you. But this is what I mean when I say a tree, a commission tree. You're exhausted, Miss Crystal. You'll see us on Wednesday. That's fine. You know, you can always finish watching this later. All right. But thanks for being here, Miss Crystal, and congratulations. Passing the national side. We love it for you. You took your test today. Oh, you took your test today and you came and do this? Girl, go take a nap or have some ice cream. Not a salad because, you know, that's explosive diarrhea. Go have some ice cream. Hello, Miss Caroline. I will have a date this week. I'm so glad you came by to say hi, but I will have a date this week for when we have our special guest coming in. Specifically, he's somebody, I don't know if you heard this, but he's somebody who's in real estate. He's basically a broker for a company. He's hilarious. And I wanted you to be able to ask him questions as well. We just had to get his life together. So he's going to let me know which Wednesday or Sunday he'll be here just for you. And of course, everybody else. Yes, Miss Valerie, no worries. If you all, I'm going to go longer tonight. So if somebody needs to go, that's fine. But I'm going to probably go for another 20 or 30 minutes or so. And you all know that you can watch it. Yes, Miss Caroline, I hope that's okay that I invited somebody else too. I wanted to make sure that you were getting the best information ever. All right, back to these questions. Do you want to do more math? I think we've done enough math. Let's jump. I can come back to that math later. Maybe we'll start next time with that math. 21. A life tenant holding a life estate in a historic farmhouse allows for the roof to fall into severe disrepair, causing significant structural damage, while spending life estate income on unrelated personal expenses. What claim do the remainder men have against the life tenant? Well, first, to do this question right, do we all understand who the remainder man, or in this case, men, are? We know when the life tenant dies, if it's a life estate, when the life tenant or the new owner dies, that interest could either go back to the original grantor or it could go to somebody completely new. And that completely new person would be the remainder man, or in this case, men. So what claim does the remainder men or the remainder man have? Is it A, a claim for permissive waste, since the life tenant failed to maintain a property in reasonable condition? I mean, permissive waste sounds not like it would be the right answer. I don't know. B, a claim for you know what? I know how to say that word, but it's not going to come out. Since the life tenant improved the market value by the underlying land. I mean, he didn't improve the market value, so I don't think that can be right, even if I can't say it. All right. Hello, Miss Caroline in the room. C, a claim only after the life tenant's death, since remainder men have no rights during the life estate. Ooh, I do like that one. Or D, no claim because a life tenant has unrestricted rights to use the property as they wish. Well, I know that cannot be the case because you're just the caretaker of the property while you own it. You own it, but you can't waste it or destroy it. And so that's why I don't like this permissive waste. To waste is to destroy. And if it was permissible, you wouldn't be suing. So I can't say it's A. I gotta go with C. And Miss Stacy, you're saying C too. C for carrots. Let's see if I'm right. Oh no, I'm wrong. The answer is A. Boom, boom, boom. Let's read this. I'm gonna read it out loud to what it says. All right, it says, now, again, this is AI. I don't know if it's true. A claim for permissive waste. Since the life tenant failed to maintain the property in reasonable condition, a life tenant has a duty to maintain the property and avoid both affirmative harm and neglect. Failing to make ordinary repairs that leads to deterioration is permissive waste, and a remainder man can seek relief during the life estate, not just after it ends. Okay, I have not heard this term before, but that is why we do these questions. Now, I, as a teacher, am going to have to go through and I'm going to go research permissive waste. I learned something too, Miss Stacy. Now, sometimes because it's AI, it could be incorrect, or it could be a term that's just not often tested in real estate. So I'll go through a couple of sources. But okay, right? So, and maybe they do have the right to make sure it's not being destroyed. I don't know. But this tells me I need to do some more research. It doesn't happen to me too much anymore, but obviously it does happen to me. But for you all, as you're studying, if you come to a question and you get it wrong, figure out why. It's okay to get it wrong in a practice exam. Now I need to research so I don't get it wrong next time it appears in a question. All right, let me actually write that down in on a Post-it because my life is full of Post-it notes. And where is a Post-it that is clean? There we go. I'm going to look up permissive waste. I would have thought that meant it was permissible, but hey, what do I know? I'm not an attorney. 22. 3 unrelated investors purchase a rental property together as tenants in common with unequal ownerships, 50%, 30%, 20%. One investor wants to force a sale of the entire property because the others refuse to buy out her share. What legal action can she pursue? Now, my thought is she's out of luck. She's a tenant in common and she can't force anything. You oughta, I mean, I guess you could ask a court or something to do it, but you can't really force it. You can sell your portion. If because it's unequal ownership shares, you could ask a court to say, hey, would you split this property up? Let's say it was just land into a 50% portion, a 30% portion, and a 20% portion. And you could sell your portion, but you can't force everybody else to sell their portion. So let's see if any of these answers match that. A quiet title action to remove other tenants' names from the deeds. No. That's no. You can't just get rid of the other owners. Don't you think I would have gotten rid of my brother and sister by now? I kid. I joke. B, nothing because tenants in common cannot force a sale without unanimous consent. All right. C, an action for constructive eviction against the other co-owners. Well, you would do constructive eviction if somebody was renting. I know the word is tenants, but we're talking about owners. Or D, a partition action asking a court to divide or force the sale of the property. I mean, I like B and I like D, but it's asking what legal action she could pursue. And I think you could ask a court to divide or force the sale of the property if something, if there was some, I mean, you can sue for this. It doesn't mean you're going to win. So I'm going to say D, but only barely, because you could ask the court to divide it, and that feels better than just doing nothing. So not B, I don't know. Okay, AI got me today. They wrote these questions. I don't know for sure. Survey says number 22. Hey, the answer's D. The answer's D. Hey, the answer's D. So, Miss Caroline, I was with you. I thought it was B too, but it says the answer is D, which makes sense. It does ask about the legal action she could pursue. Didn't say which legal action she could win. So, there you go. 23. Look at me, making best guesses here, making best guesses. A subdivision's recorded declaration prohibits any structure taller than 2 stories. A homeowner begins building a 3-story addition. Neighbors object, but the HOA board has not yet acted. What is the neighbor's most direct legal remedy? So what can the neighbors do when this person is breaking the recorded subdivision declarations? I know you can't burn it down. That is not allowed. Is it A, file a mechanics lien against the homeowner's property? No, there is no work but done on the property. B, seek an injunction in court to enforce the restrictive covenant and halt construction. I like that. C, do nothing because private restrictive covenants are unenforceable once construction has begun. No. Or D, report the violation to the local zoning board, which can override the covenant. Well, they can't override the covenant, and the local zoning board doesn't care because it's a subdivision declaration. So our answer is B. All right. 24. A survey reveals that a neighbor's fence extends 8 inches onto an adjoining owner's lot, a condition that has existed for 6 years. Okay, 6 years. And there's a fence, and it's 8 inches onto the lot. Well under the state's 15-year adverse possession period. What is the adjoining owner's best course of action to resolve the encroachment? It's amazing what you can do with a lighter and some kerosene. No, do not do that. A, request that the neighbor remove or relocate the fence or negotiate a formal license or easement agreement for its continued presence. That sounds nifty. B, assume the fence line shown on the neighbor's deed controls all surveyed boundary. I don't like that. We're not assuming anything. C, file for adverse possession against the neighbor to claim the dispute is stripped. Well, adverse possession could be an interesting answer. Or D, take no action since the encroachment automatically becomes legal after 5 years. Well, that's not true because they said there was a 15-year. So it's A or C. So we got a survey. We got 2 lots. And a neighbor's fence extends 8 inches into an adjoining owner's lot. So let's see, this is the neighbor, and this is the adjoining owner. And so a neighbor's fence is 8 inches here. What is the adjoining owner's best course of action to resolve the encroachment? So we're looking at it from the adjoining owner's point of view. They want to make sure this encroachment goes away. So they would not be looking for adverse possession. Adverse possession would be if the neighbor wants to claim. The neighbor would want adverse possession and say, hey, this is mine now, if it had been 15 years, but it hasn't, which means our answer for 24 has to be A. Just request that the person move it. Get your stuff off my land. Thank you very much. All right, 25. After closing, both the buyer and the seller discover that the legal description in the recorded warranty deed contains a typographical error in the lot number, though the intent of both parties is clear from the rest of the transaction documents. What is the appropriate remedy? Call your attorney. That's the appropriate remedy. Call an attorney. But let's see what we got here. Is it A, the buyer must file for adverse possession to establish the correct ownership? Well, we just talked about adverse possession. That's not it. B, the parties can execute and record a correction deed or a deed of confirmation to fix the error. I like that. And I do know that a deed of confirmation or correction deed is a thing. That's why it helps to know your vocab. C, nothing can be done once a deed has been recorded. That's not true. Or D, the entire transaction must be unwound and title returned to the seller. That is not true either. Our answer is B. Good job. Good job. 26. A divorcing spouse wants to remove her name from the title of a marital home quickly without making any promises about the condition of title. We talked about this earlier. Which one of those deeds basically is hot potato? I'm just giving it to you, no promises. Which type of deed is she most likely to use? Special warranty deed A, quitclaim deed B, general warranty deed C, or a bargain and sale deed D. Luckily, we talked about this earlier, and she is most likely to use a quitclaim deed. Now, if anybody who came later needs me to go over this, I can. Not a problem. And I guess we'll go up to 30, and we'll start with 31. We'll go back and do some math, and we'll start with 31 on Wednesday. 27. A buyer walks into an open house with no representation agreement and spends an hour discussing financing details, negotiation strategy, and confidential concerns with the seller's listing agent, who offers advice as though representing the buyer's interests. Womp, womp. No written agreement exists. What has likely been created? Okay. A, no agency relationship exists because agency can only be created in writing. I know in North Carolina that's not true, so I gotta say that can't be true because, this is the national portion of a test that's not going to work because I know at least one state that's not how it works. B, a sub-agency relationship automatically covering the buyer under the listing agreement. No, you're the agent of an agent. That buyer is your customer. End story. That can't be B. C, a customer relationship only, regardless of how the agent behaved toward the buyer. Or D, an implied buyer agency relationship based on the agent's conduct, even without a written agreement. I'm going to go with, D. And here's my thought process. The reason so many states, not all states, have written buyer agency requirement is because you can create agency. Remember, agency can be created expressly. I can spell express. Or it could be created through implication. It could be implied. Or it could be created through estoppel. Right? So, or by law. So yeah, there could be an implied buyer agency. That may be frowned upon or illegal in your state, but it can happen. Versus a customer relationship only. In fact, I know the reason why a lot of states even practice buyer agency is because there was a big old lawsuit about C in the 1980s. It was on commercial real estate, and these listing agents were talking to buyers and like they were buyers agents, but yet they were really sellers agents. And those buyers came along and sued and said, hey, if it walks like a duck and it talks like a duck, dude, you actually do owe me some agency here. So our answer is actually going to be D, I do believe, but let me check. Yep, the answer's D. Tricky, tricky. All right, 2 more. A property manager collects security deposits from tenants and deposits them into the same operating account used to pay the building's utility bills and staff payroll. No money has gone missing, but the funds are not segregated. What has the property manager done? So they collect security deposits from tenants and they put them in the operating account, the same one they use to pay bills. Oof. What have they done? Have they converted client funds since payrolls and utilities were paid from the account? Is it B, nothing improper as long as the total balance never falls below the amount owed to the tenants? No. This is a big fat no. Commingled client funds by failing them to keep them in a separate trust or escrow account. Or D, violated fair housing laws. Well, they didn't violate fair housing laws. So we're down between A and C. Right. And I'm going to guess here, I would have said that you commingled because you mix them. If you actually use them for something else, I would have said converted, but because they just mix them, I'm going to say C for commingled. Good job, Miss Caroline. And 29. A developer pays a landowner $25,000 for the exclusive right to purchase a parcel at a fixed price anytime within the next 18 months with no obligation to actually buy. Sounds like an option. During that period, can the landowner sell the parcel to someone else? No, because the option period contract binds the landowner to hold the property for the developer during the option period. I like that. No, but only if the developer also has a recorded notice of pending sale. Would be helpful, but it's not required. C, yes, as long as the landowner refunds the $25,000 option fee to the developer. Hey, that's the thing. Option fees are not necessarily refundable. They're usually never going to be refundable. Or D, yes, only because the developer, not the landowner, is bound by an option contract. Nope. In fact, the landowner is bound and the developer is not. So our answer is A. And last question of the evening, we went for an hour and a half today. Two neighbors verbally agree that one will sell his vacant lot to the other for $45,000. Shake hands and the buyer pays a $500 deposit in cash with no written description. The seller later backs out. Can the buyer enforce the sale in court? Well, before I answer this, I just want to remind you all, since I'm going to, be doing a live recording of some questions. If you're interested, email me. I'll probably try to do that sometime this week or the beginning of next week. So just email if you want to be involved. I need about 5 or 6 people for that. So can the buyer enforce the sale in court? Yes, because a handshake agreement between parties is treated as a binding written contract. No, because this is where our statute of frauds comes in. If you want your agreement to transfer of interest in real estate to be enforceable, it has to be in writing per the statute of frauds. So, yeah, no. Can the buyer enforce the sale in court? No. So yeses are not the answer. And C says no, but only because the amount was under 50,000. Nope. B even talks about the statute of frauds. No, because contracts for the sale of real property generally must be in writing to be enforceable under the statute of frauds. Yes, ding, ding, ding. That is our answer. And whew, we did a lot tonight. We did an hour and a half, but that's because I am now live on TikTok. So if you know somebody who needs help, tell them to join us on TikTok. And remember, email me if you want to be involved in a live recording that it's live, but then I'll record it and then put it on Facebook. It's free. All you got to do is show up and you can ask questions. Otherwise, people, have an amazing week. Can you believe it's August already? And I will talk to y'all soon. Bye, everybody. Bye.